you for inviting me to this program, which is so timely and so critical to women's rights, to development, and to global peace and security. Moreover, this topic is so dear to my heart and my entire professional career. Women are key to democracy and to development, and both those terms need to be redefined. Democracy must be judged by criteria that highlights whether or not women have equality in power and are equal partners in decisions around the distribution of resources and economic and development aid. Development must be assessed in terms of whether it will really, truly lead to structural adjustment. Now, I have my own definition of structural adjustments. By that term, I mean development should promote ending the regime of legal and political structures built on patriarchies and run by male oligarchs. True development is transformational. Those structures have to end, and they have to be new political and legal structures that are structured on women's equality in fact and in power, and enforceable mechanisms to ensure that all people receive their internationally guaranteed legal rights. International law, of course that's where I'm coming from, is a key tool for women, and it's certainly too important to leave to lawyers. Women's rights to equality in power, in decision-making, and participation are not soft law. They are binding laws set forth in human rights treaties, Security Council resolutions, and international humanitarian law. Too often, I think, men get laws and women get gender mainstreaming policies. Women are entitled to have their rights under international law advanced, respected, and enforced at country levels by all UN actions, by all UN agencies, and they must be foundational to multilateral donor-initiated development projects. And women have a right to reparations and redress for violations of rights under international law. At this point in history today, women have more rights than ever on paper, yet billions of dollars are poured into post-conflict so-called programs such as multi-donor trust funds and DDR, and they're working to keep those rights on paper and not put them into practice. The most radical thing that could happen in the world today is that international laws for women be actually enforced. No more new laws. Enforce the one we have. I want half women judges, parity in the presidencies, and development aid decided by women. Now, as an expert in international law, my current focus is the rights of women in conflict and post-conflict. So I want to focus a little bit on the development and humanitarian aid assistance given in those situations. Although first and foremost, everyone knows that conflict and post-conflict are often one and the same. I could never understand why the 2005 so-called peace treaty in Sudan marked it as a post-conflict country where its president and executive officers who are war criminals would be entitled to aid according to their own plan amounting to billions of dollars. So what I want to do, because I only have 10 minutes, is just go through some of the legally enforceable rights that women have and start in suggestions on how to really get them. And one avenue is through pressuring donor countries such as European Commission and Norway, who are bound by law not to violate rights in how they give aid to other countries. So first I want to look at international humanitarian law. Now this covers both conflict and parts of post-conflict, and this right trumps every national law when it violates the principles of international humanitarian law. So, and it also requires that there be it's got the strongest equality protections of women in the world, stronger than human rights law, stronger than any national law. Why? I'll tell you why. Because international humanitarian law, the Geneva Convention, stated as earlier as 1948 that the outcome of implementation of these laws, such as in medical care, must not be less favorable for women than for men. And that prohibition, and a violation is a breach of the conventions, covers every single aspect of protection, assistance, choice of weapons. So adverse distinction is never being leveraged, but it's starting to be recognized. For example, the UK said its aid partners must not follow local laws on abortion when they're treating a victim of war rape, because Geneva Conventions requires that person get all the care they need, and Geneva Conventions entitle all doctors providing the care complete immunity from prosecution. So these rights are non-derogable. That means that it doesn't matter about your state laws, it doesn't matter about your country plans, it doesn't matter about indicator monitors, it doesn't matter about Paris declarations. These are non-derogable in all circumstances, and the kind of aid agreements or voluntary agreements that you consent to do not derogate those rights. There's no issue of sovereignty. These rights are so fundamental, they're deemed to belong to the international community. And the law then is that these don't penetrate sovereignty, because the very essence, they go to the very essence of the global community. So the issues about state sovereignty and going along with the country plans does not ring true with this. The international humanitarian law doesn't just bind countries in conflict, it binds non-party armed forces, it binds third-party states in how they give out their humanitarian aid in conflict. It binds private contractors funded by states, including NGOs, including the United Nations, the Red Cross, and including private military contractors. States are accountable for the private actors they employ to give services within the context of armed conflict. Furthermore, unlike national law, there's positive duties to act. The United Nations has increasingly become active in the area of international humanitarian law, mainly through the Security Council resolutions. But you couldn't go to one UN agency and say, well, how many of the people you're helping on the ground are covered by international humanitarian law, so you have to treat them differently. They're guaranteed rights. If you don't provide them, they get redress. National law don't apply. So despite the increase of UN involvement in women in conflict, there still is no differentiation or no protection of the rights of women under the Geneva Conventions, which, like the rights of men, must be honored and are non-derogable. Furthermore, women's rights to reparations and redress are enhanced by advances in international law insofar they involve breaches of the laws of war. And under the laws of states' responsibilities, which is kind of old customary law that finally got codified after a committee of the UN working for 49 years, says that when there are gross breaches, and they say such as breaches of the laws of war, that are so serious, all states must act, and they must act to stop it. They must not give aid or assist the breaching state, and the breaching state must be responsible for reparations and redress. So the laws of states' responsibility over the last 20 years have been developing to reinforce the rights of people who are really being governed by the rule of law. Now, I'll have to go really quickly. I probably already reached my time. Now, international human rights law also applies to women in humanitarian aid and development. There's a lot of human rights treaties. The ones I'm looking at in particular are CEDAW and the ICCPR because they have required states to take affirmative action on measures to get women equality, including to participate in development and including in political power and voting and civil rights. So if a donor country that's ratified CEDAW gives aid without conditions to a country like Sudan that, of course, beyond other things, violates CEDAW with it, the donor country is violating a provision of CEDAW that says one treaty member shouldn't take an action that makes another treaty violate the rights of women. So there's a duty not to assist any other states, and I would say that 90% of the development money going out today, billions, assists states in violating their rights under CEDAW, and yet no one has pointed that out. So the rights to redress and remedies under human rights law in general are not as strong and absolute as those under international humanitarian law, which is another reason that UN agencies, multinational institutions, and countries have to start seeing they comply with the rights of women in situations of armed conflict. So women can have these international rights, or should have them enforced, increase their rights as decision makers early on. I've often said that by the time you get to constitution drafting, the game is over. Ceasefires are pre-constitutions. So early on, peace negotiations, and constitutional drafting all must include women as equal partners. And when you write a constitution, you can't just write anything. You're bound still by certain fundamental international laws in how you write that constitution. I remember reviewing the Constitution of South Sudan for some women's groups in South Sudan, and I said, well, you're asking for rights that are less than you're entitled to under the African Protocol. You know, you can't be drafting a constitution that you self-decide to take away rights. You've already got them because successor states are deemed to have the same treaty obligations as the state they're succeeding from. Transitional justice, reparations, and DDR are also bound by these laws, and they also systemically discriminate against women. But I think most probably key to the topic of today's is development aid and planning on resource allocation. That is where women are losing out. Despite all these new laws, what we have is a funding mechanism in this world of billions involving donor trust funds, common humanitarian funds, DDR funds, all of which gather enormous sums of money that block rights.